Thank you for taking a few moments to review the contract to buy and sell. There's no rush to find the home you want, but things may start to happen quickly once you do. We may need to get your offer submitted right away to compete with other buyers. So we want you to be familiar with the contract before we get to then. That will reduce the stress and make things much easier for you when you find the right place. When you do, there will be a date on the contract. We've explained before, but the black and white portions of the contract are real estate commission approved boilerplate. We're not allowed to change them. As real estate agents, we are allowed to fill in the blanks. Your property, your situation will be unique, so what we fill in the blanks will customize your contract to you and may not be perfectly represented here. Our goal is to give you an overview of the contract so that you're at least familiar. This will become then between you and the sellers. So we're going to want to make sure that your name is recorded as you want it to be on the title. If you are an individual, you'll be buying as an individual, perhaps as a corporation or something like that. If you are a couple, then you would probably be buying as joint tenants, which means if one of you were to die, the other would own it entirely without it going through probate. Or if this is more of a partnership, then you could own it as tenants in common, which would mean that you could separate your ownership interests and will them separately. The property described here will be described by the legal description of the property and then also by the street address that everyone knows it as. The contract makes clear that everything that is permanently attached to the property is part of the property. You can see the wording here. Take time, pause it, and read it if you want, including all the remote controls that there may be for garages. We then additionally list things that could potentially be removed, such as appliances or window coverings or other items, if they are intended to be part of the contract. We also list then parking and storage facilities that may be in place, and then anything that is being excluded. Obviously, the seller's personal belongings, maybe there's something that you would like removed as part of the contract. We are writing this to display what you are asking for. The sellers can sign this and make it a binding contract, or they can counter it and give us the counter proposal that they would prefer, or they can simply reject it outright and choose someone else's offer. Well rights, if they are included, would be the well permit would be listed here. The summary of the contract then is this dates and deadlines, and I'll not cover this in great detail at the moment, except to explain that typically we write the contract with 4 basic phases. The first we'll call discovery. Actually, the first thing that normally happens is earnest money needs to be turned in within typically 3 days or so after mutual execution of the contract, is what the MEC stands for. We'll have typically real dates in here, but usually within a week or so, we expect to get the title commitment from the title company that outlines that they have researched the ownership and that they have given us a list of what must be done to transfer the ownership from the seller to you, and also a list of any exceptions or limitations to your ownership rights once transferred, things like property taxes or covenants that may apply. And then you will have time to review that and object if necessary. We'll have another few days to sort out with the sellers any resolution that may happen. So that is true for things that are of public record, also for off-record matters, things like leases or things that might not be publicly recorded that would affect your ownership rights. We also will ask in the same timeline for association documents, if there's a homeowners association, including all financials and meeting minutes and all of those things. And again, you have the right to object. In this case, typically they can't be changed, so you have the right to terminate the contract because of them. Anywhere that it says object, you actually can terminate without penalty. You do get your earnest money back if you are terminating for a legitimate cause. Other things that are part of this discovery phase would typically be due diligence documents from the seller, meaning documents that they have on systems or the property itself, so that you have time to review those and object if you want. Phase 2 then is inspection. You have the right to do whatever inspections you want. We generally recommend at least a good general inspection, often recommend with it a sewer scope and radon test. Having done the inspections, then you have the right to object or to cancel the contract based on what you've found. If you object, then we have a few days to negotiate with the sellers. Typically, we write the contract to give about a week so that they have time to research and we can come up with a resolution that you are happy with. Along about that same time, you also have the right to terminate if you're not happy with what you can line up for insurance. The third phase then would be appraisal, assuming that you're financing. And your lender will hire the appraiser, but the appraiser will go in and independently evaluate to make sure that the price that we are paying in the contract fits with the market conditions. And then we'll have a week or so after that for the underwriters to finish up the job, prepare the paperwork at the title company, and take us to closing. The actual date of closing will be your choice for us to propose. Normally that's about 30 days, and typically possession happens when we close and when the loan is funded. We will give the sellers a little bit of time to consider your offer and to respond to us, typically 12 to 24 hours, but that may depend a little bit on deadlines that they have put in place or the competition that is there. The next phase of the contract then is the purchase price and terms outlined in this table. The purchase price, typically there is earnest money that's roughly 1% of the contract price. And then if you're doing a loan, we show the amount of the loan here, which shows the remaining down payment. The earnest money is credited toward your down payment, and the two lines balance. The next paragraph talks about seller concession. If you are asking the seller to help pay the closing costs associated with your loan, we would put an amount here that we are asking them to credit. This is really a discount from the seller, but it goes to help offset your loan costs. Typically, if you are able to make a significant down payment, that's not appropriate, but we'll talk about it case by case. Your earnest money then will be typically either a personal check or a wire transfer, and it will be held by either the title company or in some cases the listing brokerage. They hold on to that money unless you terminate the contract, at which point it is returned to you, or close, at which point it is credited toward you. The only time that it would go to the seller is if you cancel the contract after all of the dates and deadlines have passed and you simply get cold feet and don't buy the house. The seller then is entitled to keep the earnest money in exchange for the loss of time on market that they've had. It outlines here that that earnest money is to be returned if the contract is properly terminated. At the time of closing, the bank will need the title company will need good funds, so that is typically a wire transfer or a cashier's check. We are certifying at the time that we write the contract that we do have the funds necessary for the down payment. This is not a speculative thing. Unless it requires selling a separate property, this is conditional on another sale, and we would disclose that elsewhere in the contract as well. Incidentally, up in the dates and deadlines, I forgot to mention that the loan application deadline we prefer to already have completed. That gives the seller confidence that you've already turned in your loan application, you're already in the process of approval for your loan, you already have the cash in place for the down payment, so you are a good risk for them to say yes to. We need to disclose what kind of loan you're going to be doing. That might be conventional or FHA or VA. Sometimes there will be a couple of options that you and your lender are still considering. We may leave a couple of the boxes checked, but typically we uncheck all but one. Assumption and seller or private financing typically don't apply because typically you'll be doing a new loan from the bank, which means we have a loan application deadline, again, already hopefully passed, and then a new loan review. Near the end of the contract, you have the chance to review, make sure that the loan is coming together, and you can terminate the contract if your loan is not going to happen. There's no need for the seller to have your credit information or for you to review the seller's existing loan because you'll be doing a new loan and their old loan will be paid off. So appraisal, we explained already. The appraiser will evaluate the property and make sure that it fits, the cost that you're paying fits with market conditions. The cost of that appraisal is typically a buyer cost, and it is part of the closing costs that your seller or your lender will calculate for you. If there is a homeowners association, you have the right to all of the documents and all of the financials and all of the minutes. You need to know who they are and what rights they have and how they collect their money and what their plans are to make sure that you are comfortable with all of that. You then have the right to review that, and you can terminate the contract if you're not happy, or you can accept the homeowners association as it is. Typically, the seller selects the title insurance company and then pays for the title policy that protects your ownership rights. Uh, Buyer can select the title company, but then the buyer pays. We also typically ask for what is called owner's extended coverage, which covers you for some significant things. Parties in possession in case we find somebody in there, unrecorded easements, most importantly, survey matters and unrecorded mechanics liens. Survey matters, typically the title company will not require a survey, especially if it is a lot and block legal description in town, but they will cover you for survey potential losses in the future. Mechanics liens, if someone had done work in the last few months and the sellers never got around to paying them, and then sometime after closing that contractor comes after you for the money or attaches a lien to the property against that, then you would have protection from this owner's extended coverage. Typically, we ask the seller to pay this. That's negotiable depending on your contract and the market conditions. Your agent may advise you separately. You have a right to get copies of all of the title documents and to review all of them. Also, anything that the seller has to disclose that is off record related to your title. You'll find out whether your property is in a special taxing district, and then you have the right to object to the title. And we have time to negotiate with the seller to see if there's a way that we can find a resolution that everyone is happy with, or you are free to terminate the contract. One thing that we like to point out is that typically surface rights in Colorado are separated from mineral rights and water rights. Mineral rights being the gold or oil or other valuable substances that may be buried underneath. Water rights being the rights to the water that flows through or over or off of the property. Typically, those belong to somebody else. Again, if you're buying in the city, probably not a big deal. If you're buying acreage in the county, then talk with your agent about that and how that might affect you. You always have the right to consult with an attorney to review the title documents and get an opinion if you are in any way uncomfortable. The title company may, upon their review, require that a new survey be done in order to issue that title policy. And if that survey is required, it can be paid for either by the seller or the buyer. We like to get the seller to pay for it if we can. Sometimes in a competitive market, we'll offer to pay for it. Either way, the survey may not be required by the title company, and then it becomes optional. And the copies would go to you and to your agent, and you would have a chance to review that. Again, you can object if you're not happy with it. We can work to find a resolution, or you are free to terminate the contract. We talked a bit about inspection. You have the right to inspect anything and everything, including neighborhood, including planned development around you. Anything that you find out that you are not happy with gives you the right to terminate the contract, or if it's something that the seller can potentially resolve, we can object. Once we turn in an objection, then the seller can choose to do everything that we have asked. They can choose to do some of the things, or they can choose to do nothing. We'll negotiate back and forth and seek to find a resolution. And as long as we can come up with a resolution that everyone is happy with, then we move forward with the contract amended by that resolution. If you cannot find a resolution that you're happy with, you do have the right to terminate the contract. If we break anything while we are inspecting, it is your responsibility to take care of it. Due diligence documents, we ask the seller to provide for us any leases that may be in effect. We typically also ask for insurance claims, inspection reports, owner's manuals, basically any information that they have pertaining to the property or to the appliances and things that are included. It's also nice to know about utilities and about what the sellers have been paying. Again, with any due diligence documents, you have the right to review them and to object if you're not happy with what you find. 10.7 here talks about if this is conditional upon the sale of a property. If you have to complete the sale of your current property to qualify for this property, we would disclose that to the seller here. We'll give them as much information as possible to help them feel comfortable, and they will take that into account in whether they accept your contract. It is required in Colorado to disclose the source of water. That's not typically part of the contract. We will do a separate seller's property disclosure or source of water addendum or both to disclose that at a later time. If it was built before 1978, there is a lead-based paint disclosure required where the seller discloses whether they know of any lead-based paint or not. Again, we'll handle that case by case. Carbon monoxide alarms are required, and the seller is required to let us know if they have been cooking meth. Once we have the contract done, we'll execute a closing instructions, which is a document signed by you and the seller, giving the title company permission to prepare the documents for our closing, to facilitate the closing, and to record that sale. Those are typically not executed at the time that we do the contract, but they will happen later. The specifics of exactly where and when the closing happens, we will leave up to the title company closer, who is in contact with everyone, pulling all the information together. And when that title transfers, generally we'll ask for a general warranty deed. This is the seller guaranteeing your ownership rights and the title company standing behind them. At that time, their liens and encumbrances will be paid off. So if there's a mortgage, a second mortgage, any liens or judgments, those all have to be paid off, and you don't inherit any liabilities from the seller. The only liens going forward would be your new loan and then any additional liens or second mortgages that you choose to put on the property later. Closing costs, there's typically a $200 or $300 fee that the title company charges to facilitate the closing, and that is normally split between buyer and seller. That is separate from the loan associated closing costs, things like origination fee and appraisal fee, prepayment of taxes and insurance, those kinds of things. That was covered above in seller concessions in 4.2. If there is a HOA, they may charge to do a status letter or record change fees, and the contract allows us to determine who is going to pay for that. Again, typically where we can, we ask the seller to do that. Local transfer tax, private transfer fee, sales and use tax typically do not apply on most of the properties that we work with. Case by case, we'll explain them to you if you need it. The state requires the seller to disclose whether they are a foreign person, and if so, the IRS may withhold some of their proceeds for tax purposes. Colorado may also withhold some of the seller's funds. Neither of these really affect you directly. In Colorado, taxes are paid in arrears, meaning this year's taxes will be billed and assessed early next year. By then, hopefully you will own this property, so you'll get the tax bill. Actually, typically your lender will be collecting money and will be paying the bill when it is due, but you will not have owned this property for the entire year. So we prorate that estimated tax and ask the seller to credit you at the time of closing for any portion of the year that they have owned it. And then the tax bill is yours or yours and the lender's when it comes. Association assessments, the title company will make sure that everything is up to date and current. If there are any new assessments assessed between now and closing, typically we ask for the seller to pay for that. Possession normally happens at the time of closing. It is possible to negotiate if the seller needs a few days to get out after we close. We would do a separate post-closing occupancy agreement. If the seller is not out by the time we close and that becomes a hardship for you, typically we ask for a daily fee that they would pay you that would help to cover and defray some of your costs. And we do have to disclose whether you plan to occupy this as your primary residence, or we would check this box if this is investment property for you. Dates and deadlines typically are moved forward. If they fall on a weekend or a holiday, move forward to the next business day, because banks and title companies typically do not work weekends and holidays. If the property is damaged between now and closing, it is the seller's responsibility to repair it to its current condition. And you have the right, if you are not satisfied with the seller's ability to do that, to terminate the contract because of that damage. Most typical in Colorado would be a hailstorm, and typically then the seller would make an insurance claim. Their insurance company would take care of repairs or replacement of the roof. If it was something bigger like a fire, perhaps it will not be repairable to your satisfaction and the contract could fall apart. Uh, if the city for some reason condemns the property, you also would have the right to walk away. When we get ready to close in 1904 here, you have the right to walk through and make sure that everything is substantially what it was and what you expect it to be. This is not a fresh inspection, a chance to bring up new issues. It's just an opportunity to make sure that nothing significant has gotten broken. We like to point out that home warranties are available. You can talk specifically with your agent about the pros and cons of those or of potentially asking for them as part of the contract. This is our chance again to point out that we are very helpful people with real estate licenses who know lots of smart people in lots of industries and will happily connect you with any experts that you need, whether that be lenders or title companies or inspectors or lawyers or tax consultants. We are always happy to give you our opinion and perspective, but we'll always be clear if we are giving personal opinion outside of our area of expertise and our license. Once we have a contract, everyone works together to make sure that, that all the dates and deadlines are met. If you are in default of the contract, meaning that you don't meet the dates and deadlines, or most typically, if you refuse to close, not having terminated timely by the deadlines, the seller, unless we check this box, cannot sue you, cannot do anything except the worst thing they can do is keep your earnest money. However, if the seller is in default, then you can pursue legal means and this contract is considered binding. Bottom line is, when you sign the contract, there are lots of questions yet to answer about this property, and you have the right to gather all the information as we go along and to reject the property or to object and negotiate resolution if you find out things that you're not happy with. The seller, once they have agreed to sell it to you, is required to sell it to you as long as you show up at closing with the money. They can't refuse to sell it to you and sell it to someone else because they offered more. If ever there were an argument between you and the seller about whether the earnest money should be coming back to you or things of that nature, then we would go to mediation and before we would go to court. Meanwhile, whoever is holding the earnest money, the title company or the brokerage, would be a neutral observer. They don't cast the tie-breaking vote. They just hold on to the earnest money until resolution is reached and they are given written instruction. Again, numerous points through the contract. You do have the right to terminate if you're not happy. If you terminate, all earnest money received will be returned to you. This contract becomes the entire agreement. Verbal agreements do not apply. We could do this on paper. We typically do this electronically. Because we are dealing with Colorado property and Colorado contracts, Colorado law prevails. That might be different from the state that you are coming from or that the seller is moving to, but Colorado law is what is important here. There's additional provisions and lots of things that we can put in there specific to your contract. I've just given you a sample of a couple of them here. One of those is if we know that we are competing, we might do an escalation clause. In this case, we said we'd pay $500,000, but we don't know, we'd hate to lose it if somebody paid a little more than that. So we said here that if they show us a legitimate offer that exceeds the $500,000, we would escalate your offer up to, in this case, as high as $525,000 to net the seller $1,000 more than the next best offer. This gives you a chance to make a legitimate offer and not worry that you're going to miss out because someone bid just a little more than you. Another typical clause that we might put in here is asking the seller to leave the property clean and in good condition. So this is the basic agreement. As with the other one, once you are comfortable with it, you can sign it and also initial it. Remember that it is a separate save event for each of those. But before you do, we'll talk through your contract specifically, make sure that things are spelled correctly, make sure that you're comfortable with all of the details that we've filled in. We can edit and amend as we need to before you sign it. Once you sign it, it is locked, and then we will send it to the seller, and we will hope and pray that they sign it as well, and the property will become yours. Thank you.